The next case is case for Hoffmeyer. Each party will have 15 minutes to present their argument. The appellant again may reserve 5 minutes for rebuttal. Counsel, how long would you like to reserve?
4 minutes, Your Honor.
Very good. I will make note of that. I will give you a warning when you have about 1 minute in your initial time. You can come close to this warning, it will be good for you. The argument is being recorded. When you present the argument, please introduce yourself, keep your voice up, and remain behind the podium. Do not use the name of any child, minor, or victim during the argument. You refer to them by initials or term like the child or the victim. We are ready to proceed whenever you are.
Thank you, may please report Andrew Harris on behalf of the appellant Samuel Hoffmeyer. We have raised 3 assignments of error in our brief. I intend on addressing the first of those today, the ineffectiveness claim. Of course, if the panel has questions about the sufficiency of issues, I'm happy to address them. The Ohio Supreme Court has recognized that an ineffectiveness claim lies where there is a failure to present readily available exculpatory evidence. That failure is both ineffective within the meaning of Strickland versus Washington prong 1 and prejudicial within the meaning of Strickland prong 2. And I would submit that that is what we have here. Principally, what we've highlighted in our brief is the body camera footage containing the statements of LR, the victim in this case, contradicting in many respects her trial testimony. These statements are readily available. Indeed, they begin mere seconds after the redacted version admitted and published to the jury at trial ends. So for instance, her trial testimony was that she and Hoffmeyer had been living together at her Weehawken apartment for 3 or 4 weeks. Her statement to officers in the immediate wake of the incident, this is 144 of Exhibit 3A, is that he had been staying with me for likely a week. So the officer, she denied being sexually intimate the night they met. She testified to the opposite at trial. Repeatedly, so for instance, at 725 of Exhibit 3A, she characterizes the relationship as one where he is staying with rather than technically living there. Uniformly at trial, she describes the arrangement as him living there.
Counsel, when you're referring to what she said in the contradiction of what she said at trial, you're talking about the document?
Correct.
And you're talking about the section that was not admitted to evidence?
That is correct.
Okay. But that is part of our record because of the process.
That is correct. So to make a point about the record, this is something the state raises in its brief. Well, only materials that are of record are cognizable as ineffectiveness claims on appeal, and where isn't part of the record, it needs to be brought pursuant to a post-conviction petition. But here, the unredacted version of the body camera was offered to the court by the state for what appeared, for all intents and purposes, to be record preservation purposes. So I would submit that it is part of the record. Certainly, it's part of the appellate docket in this case. And this court could certainly consider the contents of that. Indeed, it would be hard to imagine how this court could ever review an excluded piece of evidence if the state's understanding of what the record consists of on appeal should be accepted here. The other point that the state makes in its brief is that it would have been, Strickland prong 1 anyway, that it would have been futile to attempt to admit these statements. And as I understand it, the state hasn't explicitly made the case that these statements were not impeachable as for the purposes of impeachment. I don't see a response to that point in their brief. Indeed, the state makes a claim that the trial court ruled these statements inadmissible, and a review of the record would say that it would contradict that. The trial court did not go quite that far. It suggested that if the issue were more squarely presented to it, that the court might find that these statements were inadmissible hearsay. But again, after some discussion about the admission of exhibits, so trial counsel indicates to the court that if the state is offering a redacted version of the body camera to the jury, in its opinion, the jury should see the entire body camera footage. After some back and forth, he admits that a better time to bring that up would have been during the examination of the witnesses, and he withdraws any objection to the admission of exclusively that unredacted version.
Did trial counsel examine any of the witnesses regarding statements on the unintroduced part of the transcript?
So he did cross-examine LR using her written statement, but a couple of points about that. So first, the written statement that he did impeach her with indicated that Hoffmeyer had been living with her at that residence for about 2 weeks. And again, there's better impeachment evidence in the body camera footage in which he said that time frame was 1 week. Setting that aside, that qualitative difference, there are a lot of topics that she touches upon in the body camera footage that were not addressed on cross-examination, and so far as we can tell, were not brought up in that written statement either. So, for instance, other than the time frame that Hoffmeyer may have been living at that Weehawken apartment, they didn't. So trial counsel didn't touch on the other indicia of cohabitation, for instance, whether there were whether Hoffmeyer moved items. And so in the body camera footage, she says that Hoffmeyer brought a few clothes there, and when presented a follow-up question by the officer, so he just has a few clothes there, she responds, yes. That's contrary to what she testified at trial, obviously, where she indicated that he brought over kitchen equipment, canisters, things of that nature, in addition to a bed, a mattress. The bed, the mattress, the kitchen supplies are something that didn't come up that night. That's another area where trial counsel failed
And
to.
counsel, was that all new at trial? Was that the first time it was presented at trial?
The first.
About the other stuff?
So the admission of, just so I understand your Honor's question, the fact that she brought up the mattress, the trial canister, so the record doesn't indicate that was brought up at any time prior. That doesn't, so certainly that doesn't appear in Exhibit 3A. Whether it appears elsewhere in discovery is just not something the record establishes. So I would submit for all of those reasons that trial counsel, consistent with the theory endorsed in the Supreme Court's Gondor opinion, that failing to present readily available exculpatory evidence is ineffectiveness, I would establish that this case bears that out. As to Strickland Prong 2, I want to emphasize that the test for prejudice is there a reasonable probability that the jury's decision would have been otherwise but for trial counsel's ineffective conduct? Is the material that the jury didn't see sufficient to undermine confidence in the outcome? So the test, just to be clear, isn't whether the trial counsel's conduct, in this case the failure to present exculpatory evidence, would entirely vindicate a defendant. The test is not whether it's establishes conclusively a defense. Here, the central theory of the defense is that LR was not a household member within the meaning of the domestic violence statute. All of these statements she made on the body camera footage tend to impugn that. I would submit that they are all prejudicial within the meaning of Strickland Prong 2. There is a reasonable probability that the jury would have decided otherwise, but for their not having heard that evidence.
So just so I make sure I understand and clarify everything for the sake of the audience here today. So the defendant was charged with domestic violence, and there's no real argument that he did assault this prosecutor. The argument is he a household member for purpose of what the charge is?
That's correct. Certainly that's the argument appeal. Now, to be clear, I think trial counsel did sketch out at least some indications of a defense along, the credibility of the testimony establishing the assault. There was some cross-examination, both of LR as well as the manager of the Dairy Queen facility. For the purposes of appeal, that's correct, though. We are just disputing the household member element of the domestic violence offense. And the ineffectiveness claim we raised exclusively speaks to that element.
And counsel, I just wanted to ask you, is it clear that the evidence that you are identifying as something that should have been presented as exculpatory? Was it necessarily exculpatory? Who makes that decision?
So I think it's an objective test, viewed under the totality of the circumstances. And here, again, the essence of the defense theory was LR is not a household member, given, among other things, the short time of the relationship and the fact that it lacked indicia of cohabitation. For instance, the fact that she testified he gets mail there as indicia of cohabitation certainly is exculpatory for the jury to hear that he didn't get mail there, as she relayed his body footage.
And what was that test look like? You raised in your brief an argument about him being on, I think it was probation, right? Probation?
Parole.
Parole, I'm sorry, parole, yes, of course. And could there have been a trial tactic, a decision to not introduce that into, put that before the jury, even though it might indicate, it might bolster the argument that you're saying wasn't developed?
So as it relates specifically to evidence of his parole address, conceivably it could be if it was part of a larger strategy to hide the fact that he was a parolee, that he had criminal history. But that was certainly not the strategy pursued from the time of even voir dire. He brings up Hoffmeyer's status as a parolee. He asks the jurors questions about it. He mentions it in his opening statement. While he doesn't actually introduce any positive evidence of where Hoffmeyer's various registered addresses might have been, for instance with the APA or the Bureau of Motor Vehicles, he does elicit through cross-examination, he being trial counsel, elicit through cross-examination the fact that parolees in general terms may be subject to those requirements. So if there was some strategy to hide the fact that he was parolee, to sort of paint him as not a bad guy for the purposes of presenting the case to the jury, it certainly wasn't a consistent trial strategy. And I think overall the record indicates that he made these strategic decisions because he was unprepared. And I would emphasize that if you review the pretrial transcripts, in addition to the transcripts that the trial immediately starts with, the sum total of trial counsel's preparations with Mr. Hoffmeyer consisted of a phone call lasting about 1/2 hour the week before the trial began.
You got yourself in your rebuttal time and answer that question if you want to continue to do, just so you know.
Okay, well, I think I made my point as to that question, and I would reserve the balance of my time for rebuttal unless there are present questions. Thank you.
Good morning again. May it please the court, my name is Rick Raley. I'm here on behalf of the state of Ohio, the appellee in this case, as well as Suffolk County Prosecutor Elliot Kulkovich. Hearing the arguments this morning and reviewing this brief in preparation for today, I'm reminded of an old adage that a lawyer is only harshest when he reads the transcripts of his colleagues. And that's certainly, I think, what we see right here. The Strickland burden is extremely high to satisfy. All trial lawyers are presumed to be competent and they are able to represent their clients. And there's well-settled law that trial tactical decisions are subject to the reasoned professional judgment of the trial lawyers who are presenting that case. And looking through this, the defendant in this case, his trial lawyer had a certain tactic that he was going forward on. He was attacking different elements of the defense. He was also impeaching convicted in this case in a particular way. He brought out that the Bureau of Motor Vehicles, that his vehicle was registered there with a different address. He brought out that the investigating officer did not confirm whether he was paroled, his parole address was at the place of the victim's residence. Based on that, he did what he could to do as much as he could to get this out.
What about the impeachment aspect?
So I do think that there is impeachment on a prior statement. There is impeachment of her claims. I have not gone through every bit of the part of this body cam, which from what I reviewed this morning, it appeared that this is the record, so I don't know why that was put into the brief. I can tell you that one of the big things that's put in this brief is that at one point the victim says that they weren't technically living together. I mean, that's an unfairly prejudicial statement that's going to confuse the jury because there's no indication that this victim understands what the standard is for living together, cohabitation under the statute. And when you look through the record, there's significant evidence of cohabitation. I want to listen here. One, the victim testified that they lived together. Two, the defense sleeps there every night of the relationship. He keeps his belongings there. He got his mail there. He changed the locks. He kept possession of the only key. And he didn't stay anywhere else during the relationship. And on all these, and I'm sorry, not only the belongings in the apartment, they go to the storage unit he has every day and they take more and more stuff out of that storage unit. That's significant evidence of where he's living during this period.
But that's also evidence that was contradicted by some of them. It was contradicted by the body cam and the interview that she gave to police officers.
Right, and I'm not certain though that even with putting, I think putting out technically living together, I think that that's something that we would have objected to very strongly if that was even raised as a part of impeachment. So I would say that I would not describe this evidence as exculpatory per se, but it is potentially impeaching. And I think when you look at the whole record, other impeachment evidence was brought, and the jury still decided, no, they're household members because of all these items that we heard about also. So for that, I think that based on a very high standard here, I think we can say it's deficient performance. There's a lot of case law about this. Calling of witnesses is something that's a trial tactic. How you impeach is a trial tactic. This is a reasonable professional judgment that trial counsel made. But if we go beyond that, I think the prejudice is lacking too, because there is evidence in the record that the jury heard that would impeach a claim that they were household members.
Counsel, do you disagree, or do you have anything in the record that demonstrates that the attorney did spend more time with the defendant than half an hour?
You said again.
I'm sorry. Do you have anything to contest? Is there anything in the record to demonstrate that the attorney did spend more time with the defendant other than the half an hour that he's allowed?
In terms of consulting and whatnot, I don't know that. I'm not sure that the record's going to reflect how much time.
But it was reflected in the record that he spent half an hour the day before.
I don't know that. I just don't. So I will say, there are times where there's discussions before trial that the case could have been pending for a long time. We could have had discussions before then. We shouldn't presume just because that was a discussion done the day before that that's the full totality of the relationship. Also, we don't know the particular circumstances. Maybe they have not met more because the defendant did not avail himself of the opportunity to meet with us. So there are all kinds of different circumstances that are present here that were not developed that we would potentially see. So based on that high burden, based on the fact that I think we don't have either deficient performance or prejudice here, I think that this court should overrule the sentence here unless there are any questions.
I have a question. Opposing counsel brings up the point in his brief that the state does nothing responsive to the Supreme Court's recognition in Gondor, that the failure to present exculpatory evidence that is available, should we conclude that there was exculpatory evidence, to trial counsel constitutes ineffective prejudicial error. Would you like to address that?
I think that, if we look through this, it's admissible evidence that clearly would have overcome the jury's verdict on this, then yeah, that'd be a real problem. I have not seen a description of evidence like that in unredacted portions of the body cam, because the defense got the same point out through other evidence. Based on that, I don't think Gondor controls the disposition of this case. that, thank you.
Thank you.
So, Judge Carr, I think to your question, it might be useful to just walk through some of the pretrial history of the case. At the first hearing in which trial counsel represented Mr. Hoffmeyer, that's July 31st of 2024, he indicated that he had not had an opportunity to meet with the client. But the next status hearing, that is September 11th of 2024, he had still not spoken with his client.
Is that all on where their transcript file leads those hearings? When you say that's in the record, how do we know that?
Correct. So the pretrial transcripts were July 31st, September 11th, September 13th, September 24th, or those pretrial transcripts do all appear on the record. And I would say that the fact that they had a phone call lasting about 30 minutes, that is appears at the beginning of the trial transcripts prior to the jury being called in for 1 year.
And did trial counsel, did they dispute that there was this was a level of communication? Trial counsel saying, oh no, I meant a lot more than what my client saying?
So the 30 minutes figure that I said in the brief, I believe it was trial counsel who said that, and I spent about half an hour on the phone with my client last week, is what he says, the day trial commences.
And that is the sum total that we'll find in the record for 30 minutes?
For the purposes of trial preparation, certainly. Obviously, the transcripts themselves aren't time-stamped. I suspect they spent more than 30 minutes together in court, but obviously that's qualitatively different than trial preparation. And I would say that obviously the failure to spend that time together did, from the outset of the trial, as you can see from the outset of the trial, impact the way the case was presented. And Hoffmeyer immediately invoked Strickland during this, again, pre-jury being called into colloquy. Says that he's not confident the trial counsel is going to present evidence of, for instance, where his EPA reported address is, where his Bureau of Motor Vehicles reported address is. And indeed, there is there's maybe general cross-examination of the idea that people have registered addresses and perhaps Weehawken may not have been a registered address for Hoffmeyer. There's no positive evidence of what those registered addresses is. Trial counsel doesn't reference other addresses in his closing arguments. They're just nowhere in evidence, which indicates maybe through oversight, maybe through, again, a lack of preparation. He failed to present evidence that he had available to him. The evidence is less clear. I would say that it's a little bit different than the body camera footage, the idea of this registered address, because there is no, at least at the trial stage of proceedings, positive evidence of what his registered address was with either the EPA, the PSB, with any other public entity.
So the most we would see on the record is trial counsel and closing argument make reference to addresses and then find that there's no evidence where any addresses were.
Correct. So trial counsel making that reference in closing argument, and also Hoffmeyer himself telling the court before the jury is called in that he has these addresses that he's worried trial counsel won't present evidence of.
And counsel, you rebuttal time is up to briefly conclude, please.
Thank you. For all of these reasons, I would submit that trial counsel's performance was deficient in both within the meaning of Strickland versus Washington. We would ask this court to reverse remand for a trial more consistent with our alternative second bear reversion of dismissal. Thank you.
Thank you, counsel. And again, on behalf of the court, I thank both of you for your presentation this morning. The court will take a matter of advisement and issue a decision in due course. The court will make a copy of that decision issued on release, and the opinion will be available on the Ohio Supreme Court website as well. With that, the court is now adjourned.